Hello everyone, my name is Melissa Janis. I'm a juror in this case. The plaintiff is Charlotte Robinson and the defendant is Aaron Correll, representing Ashford Hospital. The plaintiff is suing Ashford Hospital for improper release of her health information protected under the privacy rule. The plaintiff is a patient and an employee of Ashford Hospital. The plaintiff alleged that her protective health information was impermissibly disclosed to her supervisor. Ashford Hospital distributed an OR schedule to the employees via email. This plaintiff was scheduled for OR at the time. Hospital's OR schedule contained information about the patient's upcoming surgery. The other information found in the OR schedule was the Social Security number, the birth date, age, residence, former and current medications, insurance and payment information, past medical conditions, primary care physician information, psychiatrists, and other healthcare professionals that she had seen through the past year. The patient supervisor was not on the OR team or patient treatment team, but was considered to be in a senior administrative position within the facility. Ashford Hospital has an ethical and legal obligation to protect their patients' privacy and confidentiality, as well as their employees. HIPAA, the Health Insurance Portability Act, was passed in 1996, provides federal protections for individually identifiable health information held by covered entities and their information, or in their business associates, and gives patients an array of rights with respect to that information. Health information in any form should be protected. At the same time, though, HIPAA permits the disclosure of information needed for patient care and other important purposes. Protected health information contains an array of patient and treatment details, especially those that have the potential to identify a patient. There shall be rules and regulations for who has access to this information. The only reasons this information should be shared or accessed are for treatment and coordination, payment purposes, the patient actually gave someone permission to view their protected health information, and public protection. Administrative, technical, and physical safeguards should also be in place to make sure all information is secure. In this particular situation, the patient's medical history should not have been sent to her supervisor. Privacy is defined as an individual's expectation to keep or control access to his or her individual space, as well as knowledge of certain information. Confidentiality is defined as an ethical and legal obligation to refrain from sharing information about other people without their authorization. In this situation, I believe Ashford Hospital violated the plaintiff's privacy and confidentiality. Under the privacy rule, the rule does not protect your medical or health plan records. The privacy rule may not apply to your employment records, but under the privacy rule, the rules do protect your medical or health information or records if you are a patient of the provider or member of a health care team or health plan. The plaintiff's supervisor is not taking care of his employee as a patient. The plaintiff's supervisor did not need to know her former surgeries, her primary care physician, her psychiatrist, or any other health professionals that she had been seeing in the past year. He didn't need to know her current or previous medications. For these reasons, I'm finding in favor of the plaintiff.